wherewithal to implement these technologies. Basically, what are the characteristics of an AI system, if you look at it? Essentially, we have to understand that computer is still a deterministic machine. It's the von Neumann architecture has not gone. We still are not into neural computing or biocomputing or any of those things. It's still a deterministic machine. It does a simple problem, but it can do it repeatedly. So the key to it is taking what's called an intelligent algorithm and converting it into a procedural algorithm. That's what we do as AI practitioners. We understand a human mind, we understand how a human being thinks, and try to write it as a procedural algorithm so that a procedural machine like a computer can enforce it. So that's the only key to it. So an AI system, typically it'll have the input, output that's goes without saying, and it will have something much more than data. You have raw data, and it will have what's called knowledge. So in terms of complexity, how data is organized and how data structures are created tend to be significantly more complex. And then there will be reasoning and also what's called meta-level reasoning. Now, let's say that you have rules for children to do something and adults to do something. Those are the basic level rules. And now if there is a rule which says that children take priority over adults, that means apply children's rules first, and then that's a meta rule. And then you can have even higher level rules like, first all substantive rules will be enforced before procedural rules are enforced. That's even a higher level. So this way you can build higher and higher level of abstraction. That's the hallmark of AI system. So with this, the level of complexity and the level of knowledge and the level of a correlation of knowledge, the ontologies, the epistemologies, all that become fairly complex. But eventually, it's still being implemented in a deterministic machine. So bulk of the AI work is taking a problem, characterizing it in a certain way so that a normal day-to-day computer can enforce it. So that's I thought I'll give a basic background before the individual speakers, start their presentations. So with this background, I will now call Parthasarathy. Instead of me describing the biodata of the speakers, I'll let the speakers introduce themselves. In terms of the topic, Parthasarathy will talk about patentability issues of AI inventions. Okay. So without much further ado, I turn this over to Parthasarathy.
Thank you, Chid, for the nice introduction, and good morning to all ladies and gentlemen. I want to start with a caveat. I'm a lawyer. I'm not an expert in the computer field or in artificial intelligence. I want you to know that first. Of course, I've been in the patent field for the last 15 years and doing a lot of enforcement in all fields of technology. But just like what we talked about disruptive technology, when we talk about it, all of us have to constantly evaluate ourselves and keep ourselves abreast of development. So even as a lawyer, whether law changes or not, at least I need to do that. So I thought I would take up this topic of artificial intelligence and talk about patentability. Now, yesterday's first two plenary sessions also, we had a very nice taste, I would say, of artificial intelligence. But very interestingly, you will know that there is no real universal accepted definition of what is artificial intelligence. And like what Chit pointed out, apart from the rebirth, which has been from 1950, the most important thing is finally all of that comes down to implementation through the computer. And that is where, according to me, we are going to have the problem with reference to patentability issues, at least with reference to India, I'm going to talk about. If you, I don't know, how does it work? The back is not working. I don't know why. Yeah, this is what I intend doing the next 10 to 12 minutes. So the developments in artificial intelligence, a brief patenting trends, patentability standard in India, and the foreseeable challenges with reference to artificial intelligence, and certain illustrative examples of some of the claims on artificial intelligence currently happening, and what is the way ahead. Now, before I go through this, see, when we talk about artificial intelligence, it is defined with reference to different aspects. For example, when you define artificial intelligence based on problem space, then we can call it as logical reasoning. It can be a knowledge representation. It is planning and navigation, natural language processes. You define them in that term. But if you are talking about overlapping subfields, then of course we definitely talk about machine learning, we talk about deep learning, we talk about artificial neural networks, expert systems, robotics, etc. Then also there is a definition, artificial intelligence and artificial general intelligence, people talk about it. Artificial general intelligence, they talk about almost like a human ingenuity, whereas artificial intelligence just at a slightly lower level, machine level. That is how people are talking about it. Now, as Chit said, it's not a new concept. As early as 1950, you can see the concept was developed by Alan Turing, the English mathematician. Then the term artificial intelligence itself was formulated in the year 1956 by John McCarthy, the computer scientist. And as I said, there is no universally accepted definition of what is artificial intelligence. It means a broad set of things. That's why we are going to see what is the patentability trend in artificial intelligence. Depending on the IPC codes you consider where artificial intelligence, it presents a number from 2000 to 20,000 also it could be. And now, of course, Vyver is trying to develop an IPC classification specific for artificial intelligence, so that going forward, when you collect the statistics on what is happening in artificial intelligence, maybe you will have a better idea of the number of patents which are coming up in this particular field. Then there is a dramatic progress in the last 10 to 20 years, which again Chit pointed out. It's because of one, availability of large amounts of data and exponential growth in computing power and cheap computing power. I think those are the two things which are really driving the artificial intelligence now. Not going back. Okay. Now see this, I'm talking about 2015, October 2015. Google has this AlphaGo. You might have heard of the game Go. On this particular AI program or AI software, we can whatever you want to call it, it beat a reigning European champion on this particular game. And it had like something like 250 choices per move. Is what is possible, and then the total number of combinations they said is 10 to the power of 360. That's the type of work. So while we talk about artificial intelligence, mainly the computing power makes the computer do a repeated number of transactions in a faster frame of time without getting tired, which is all not possible with reference to individuals. And one set of trend talks about the number of patents in artificial intelligence as between 700 in 2012 to going up to 2,888 or about 3,000 in the year 2016. Now, if you look at the patentability trends, as I said, depending on the IPC code, this is also from WIPO source. Depending on the IPC, it varies from in 1998 to 2017 of almost like 30,000. So again, what is artificial intelligence, which type of inventions are to be classified under AI, and how they are to be looked at, I think there is still a lot of variation, because of which we get a lot of different figures. The major jurisdictions, again, in that you call, talk to the US, China, Japan, and then WIPO, EPO, and India also. India also, they talk about 10,000, because we are going to see most of it is going to be computer implemented inventions. So we also have a lot of such applications filed in India. Now, before I get into subject matter eligibility, I wanted to talk about a few things. You may all have heard about IBM Watson, a program which is used for the TV show Jeopardy. I don't know how many of you know that. So this again, one of the artificial intelligence developed in order for the game. And what is important is Watson itself is capable of generating inventions. That's another aspect. One is I create an artificial intelligence program, product, or method, and that itself in turn creates another program or another product which is also based on artificial intelligence. That's where we have questions regarding when an artificial intelligence machines create by itself another invention, who is going to be the inventor? That's again a topic where there are again divergence views. When everything starts with the human being, any derivative from that also the inventor will be the human. The other is the machine itself is an inventor. Then does the patent law, does it require any change in order to capture this particular changing scenario, is also an issue which is happening. Similarly, I don't know how many of you have heard of this a program called CLOEM. Instead of claim, CLOEM, C-L-O-E-M, a French one, which can draft claims based on the inputs which you are given and they give it to you. And they are talking about almost 90% accurate as far as the claims are concerned, which is a natural language process based program. Similarly, you also have alltheclaims.com. That's one. And similarly, allpriorarts.com. You have to look at them. So it can look into all the prior arts and then analyze what you are giving the input, give a complete specification, write a complete specification, also a claim which is again claimed to be 90 to 95% meeting the requirement. And then of course, our role comes in order to draft and make it, the finer points probably we'll have to make it. Similarly, there is another artificial intelligence instrument called Specificio, which is meant only for drafting patent specifications for computer-based inventions. So, what we are talking about today is, as a disruptive technology, we are talking about various types of artificial intelligence-based inventions, products, or processes, which are likely to take over and do most of the work which is done by the patent practitioner today in the field of drafting. And of course, what are those things when it comes to drafting? When you get it, my other co-panelists are going to talk about. But when I am talking about patentability issues, when you talk about patentability issues, the most important point, according to me, is what Chit said. At the end of it, all of it is computer implemented inventions. You are getting a determinate thing, a computer is going to be there. How the computer, the power will improve, what are the other things they like, but fundamentally they are all going to be computer based. And that is what troubles me as far as patentability in India is concerned, because as you all know, software program per se is not patentable. We are still grappling with per se itself, even though we are trying to follow the European model, and then we are trying to talk about a technical problem and a technical solution and how it makes the computer a better computer or it does something more in a technical field. Even with that type of availability of prior knowledge, we still have problems with our patent examiners and the controllers in getting patents for very ordinary computer inventions. Now, going forward, these are going to be even more complicated, but still are finally going to be computer implemented inventions. And some of them, it's possible probably you can show some technical effect. In many of them, you may not be able to show the technical effect. So I am foreseeing a problem that in future, in the higher realm of artificial intelligence, when you are talking about patentability in India, 3K is going to be a major issue. unless and until there are clear directions as to how 3K is to be implemented, or the law itself gets amended, we, according to me, will still face a lot of problems in grant of patents in India on artificial intelligence-based inventions. Now, look at this particular claim. Very quickly, this is a computer-implemented method, receiving, processing, providing. You are receiving a signal, and that signal is in a neural network, and it is an automated voice activity detection system to see whether there is a raw audio waveform. Then the neural network processes it to see in the audio waveform, is there any voice? Is there a voice? It includes speech. And then providing by the neural network a classification of the raw audio waveform indicating that it includes speech. So it's a simple claim. It is a Google 2018 patent filed in India. It's awaiting examination. This is the first independent claim of that particular thing. So you talk about receiving a raw audio waveform, processing it to see whether it includes speech, and if so, identify that particular speech. That's all. It is such a broad claim we are talking about. So if you are looking at this type of claim, if it is implemented through a computer, whether they are going to say it's purely is a computer program per se, it is implemented, let's say, on a known computer, no new hardware, what technical effect does it produce? The software itself identified from the audio waveform what is the speech, and then trying to identify the speech and take it out. How an examiner is going to get grant a patent for that? I am eagerly waiting the examination report for this to see what type of objections are likely to come up. Similarly, look at this claim. I am not going to read because that will itself take up my time. This is again a Google filed patent on artificial intelligence in India in 2018. It talks about a system. It itself talks about comprising of one or more computers, one or more storage devices. So forget all of them. Deep machine, a wide machine, a combining layer, all that. But you are still talking about a computer implemented invention. Therefore, this again is going to be a major problem which I am talking about. I took 3 or 4 examples just to show that even in artificial intelligence, the type of claims, you can say that they are what again Chit said, very important, computer implemented. Therefore, it is not because of artificial intelligence we are going to have an easier examination thing. More and more it's going to be difficult to get it because we have computer program per se, algorithms, mental acts, all these which are coming in 3K are going to really affect patentability in India unless and until we have clarity. Therefore, I think mainly what I wanted to show was that you have 3K and 3M. The problem is there. 3K excludes mathematical, business methods, computer programs and algorithms, schemes or rules for performing mental acts. Some of them say you are doing mentally. When you talk about Go game, you are mentally determining, or even a chess game, you are mentally knowing how to determine what movement I should make. Because of the artificial intelligence, the program also tries to make those combinations and say I will make this particular move. So whether whatever is being done by the computer through the AI thing, is it only a mental act of moving a particular thing from one place to another? Therefore, if it is a mental act, therefore it is not eligible, whether we are going to have a problem. So we have similar EPC provisions, and while you have some explanations on what is computer program per se, algorithms are completely banned in India, and most of it is going to be algorithms. Most of it is going to be algorithms at the end of the day. So the 3K and 3M in the present form and with the present type of problems which we are facing in India with normal computer software programs, etc., tied to hardware, known new hardware, producing technical effect, not producing a technical effect, I think there is a major issue on patentability in AI. These are things I think all of you know, so I am not going to talk about mathematical method, computer program per se, algorithm in all forms are banned. So unless and until the final claim is going to link it with a technical subject or a technical matter, it stands as it is. I think there is going to be a major problem. That is where both Tarun and Aditi are going to talk about drafting methods by which you may try to overcome this particular type of objection, how they are going to do that. Similarly, subject matter, as Sid said, all are computer related inventions. Therefore, we have computer program per se, we have mathematical method, algorithms, mental act. Each one of them, I think, is going to have an impact on this. So definitely the first thing is the examiner is going to say, is it a computer program per se? Then even if it's not there, some of them, when we are talking about machine learning or we talk about deep learning, they all have computerized models. We are talking about only models towards classification, regression analysis. They may be implemented with new hardware. If you have new hardware, I think at least you overcome the problem and you'll be able to get a patent. But chances are we are not going to have new hardware every time. 99% of the time we may not have a new hardware, which means we are going to have a problem on this particular aspect. Similarly, mathematical methods, because all of the computational models are there, then only when the models are claimed, obviously they are not going to get it, they are going to be abstract. But if they are talking about technical means, whether we are going to overcome that, I think the entire thing is to seek protection for core AI model approaches is going to be very difficult. It has to be tied up to some amount of technical work or say technical feasibility for India to grant a patent, unless of course the guidelines, which definitely do not have the legal force, are also keeping march with the pace of time and change of technology, or the law itself changes, or the judges interpret the law. Because despite the computer programs per se being there right from 2005 onwards, we still have problems. And only I think 2 or 3 weeks back, Justice Pratibha Singh had given some instructions on how to go about examining a computer related invention. So it becomes very, very important to have that all examiners and controllers have work on the same basis, so that you don't have the idiosyncrasies of the individual patent examiner and controller determine whether a particular patent should be claimed, should be granted or not. Similarly, algorithms, I think because of the broad exemplification, you have to have a problem from patentability, most of them. Mental act, as I said, this is also, I am pointing out, it's going to be a problem. Now, I am just going to have one point. Can you tie in the subject matter with an area of application or a technical purpose? I think that's going to be the crux of the issue. Instead of being abstract or nothing, can it be tied to a technical subject? Therefore, I just thought I would give you 2 examples of claims and then close my subject matter subject to questions. Now, this one you can see an SVM algorithm. It is a computer-based system training a multi-category classifier using a binary SVM algorithm, set method, comprising, etc., all these things. Now you can see it is restricted to SVM classifier. It recites only a type of training and building. It is directed more towards a mathematical model, and it is largely abstract, and definitely will face objections on mathematical method and compute. So this vector method of thing, I think is going to create definitely a problem. Whereas look at the next claim. If you look at the claim, I think you will have a lot of confusion. There also it talks about a proportional, integrative and derivative PID controller comprising a proportional element, and you have big mathematical formulas coming in there. Now the progressive, integrative, proportional, derivative, etc. But what we are talking about is the controller. So it's tied to something. And what the controller is talking about, to cause a plant to generate a plant output. So you are having a controller and it has a plant. Then actually, in a way, if you simply see an example, if I remove the abstract and tell you an example, if you replace the plant with an automobile, therefore the controller is the engine control unit, and then you are talking about receiving inputs or signals from throttle control or various things, and based on that input performing certain things, then you will find it is a real world application which you are talking about. So the way the claim is worded, because the controller and the plant is tied with reference to an automobile because of the specification, you get that example, then there is an hardware element and also a real world application. So the chances of a patent of the claim of this nature getting granted seems to be much higher than the previous one which I was talking about. Therefore, all that I wanted to conclude by saying is a highly transformative technology, there is no doubt at all. Will have a wide impact, that also is not a problem. But the most important thing is getting a patent granted for it in the present scheme of Section 3K and 3M in India is going to be a challenge. That is probably where the drafter skill could come, and probably AI will not be able to replace the drafter skill, and you must still have a role in order to get a claim of this nature for a particular thing granted. Thank you very much.
Next, we'll have Tarun talk about specification drafting for AI-based inventions.
So, very good morning to everybody. I think Partha sir has set the ball rolling very significantly on what kind of issues that can come on from a patentability standpoint, particularly 3K, because that's where majority of the trouble comes to the people who are prosecuting applications in the space of AI and computer sciences in general. And I'll try and give my few pointers on what kind of approaches do we guys at least adopt while we are drafting applications for Indian entities or for foreign companies while preparing applications, which actually are not very, very AI specific all the time, but can be sort of elaborated and generalized to other areas of computer science and software applications as well. Very quickly, I'm Tarun Khurana. I'm a partner at Khurana and Khurana IP Attorneys and focus on enforcement as well as prosecution matters in the computer science space. So this is a very generic representation of the kind of space in which applications in the AI field are filed. You'll see here applications being filed in the space of robotics and control mechanisms and automobiles and a lot of other application areas where all types of machine learning, AI algorithms, and data learning, deep learning, neural networks, all of these are applicable in almost all of these fields that I've mentioned here. But this was just an exemplary snapshot of a report that came up from WIPO, indicative of what all industrial applications have most prevalence in the AI space at this point in time, and hence wanted to identify. And within the respective space, it also gives you, as regards natural language processing, what kind of algorithms are the most prevalent ones from an IP standpoint, from a protection standpoint. Not very clear again, but indicates the core classifications of AI. It talks about machine learning as the first highest classification as regards the patentability activity. So the most applications are filed in that space, and then within then what's the bifurcation within the machine learning. So if we can sort of see the space here, even I can't read the screen there down there, but the first is machine learning, and then there is logic programming, and then there is fuzzy logic, and within the high level categories there are numerous subcategories. Again, this is part of public domain and therefore can be reached out, and I'll focus on the other aspects. Indicates the top applicants in the space of AI particularly. This is again part of the WIPO report, and I'll come to it if time allows at a later stage. Yeah, so these are the main AI models that in the current space are being protected from an IP standpoint. The first is regression. There are numerous regression techniques, linear, non-linear techniques, what kind of algorithms that are having applications for each of those techniques. They're sort of a subject matter of high level of patentability. There are obviously neural nets, there are reasoning machines, there are support vectors, there is logic programming. All of those are main areas of focus when somebody does patenting in the space of AI. And I just wanted to elaborate on it because I'll have a few examples which will cover these spaces and give examples of how people are actually drafting applications in these spaces so as to cover and overcome the subject matter eligibility issues from a 3K standpoint. Right, so these were the key pointers that I wanted to highlight from a drafting perspective of whenever somebody gets issues on subject matter eligibility. The first one was the focus on technical contribution and improvement. We see a lot of these applications, and in fact, the one that Partha sir also shared the example of talked about neural networks. It just talked about the neural network or a neural network engine as a generic statement. It talks about machine learning algorithms or a machine learning model or an AI model. What has become very fundamentally clear is that most examiners are not appreciative of a mere model or a mere term being used which is generic in the true sense of it. So if you just merely mention that you are receiving at a neural network a set of data packets to do something and then processing by the neural network those set of data packets or a set of data packets retrieved therefrom, examiners not going to appreciate the fact that merely because it's a neural network that you're trying to claim, give him a patent because he's in a space which probably would involve computational sciences at the back end. Generic expressions like machine learning algorithm or a machine model or an AI model these days is completely outclassed. When we do prosecution and we make an argument of that nature, examiners are not appreciative of generic models being talked about. If you're doing something in the model, if you're actually changing the model per se, then we have to explain it. Otherwise, merely receiving it by a model, an input, and then giving an output through a model which has not been described as regards how that model actually processes the data packets that are coming in as regards the input is absolutely not of any appreciation. So even if you have claims directed to that stage, either, and I will reiterate it because it's in the subsequent slides as well, either we focus on the novelty being on the input that is coming in. Now, for example, if there's a vehicle that is generating a certain set of sensor data and another sensor data, two sets of different data packets going into a known model, and there's an output where there is a correlation between the two data packets which is being formed out, then there's an interplay of what input went in and what output came off, and that is where the novelty was, because perhaps nobody in the prior art actually correlated the two sensor datas. But unless we actually elaborate on the model per se, on how that model is being constructed, merely by using the model as an interjectory statement would not add a value from a patentability standpoint. And therefore, we have to talk about the key technical contribution that the model essentially has and how it is being created, rather than just using it as a placeholder. Now, we have to limit our arguments also to the maths involved. Now, there was another example that was given where there were a lot of equations. But unless we tie, as very correctly said by Parthasarathy as well, unless we tie those mathematical equations to an industrial problem, unless we say that, okay, this is the first input and this is the second input and this is the regression algorithm or a correlation algorithm that I'm going to use, and output of which will be used in this particular industrial application so as to control this controller, unless we draw a clear correlation between the mathematical equation and the output thereof to an industrial application, we will again have problems from a patentability standpoint. And therefore, the claims should almost explicitly mention how the output of that mathematical algorithm or the equation is going to be used in an industrial application. And that tie-up is very important. Go back. So the third point, if the core inventive step that you're claiming, a lot of companies that we represent, including Daimler and KPIT and many others, they come up with scenarios where the inventors are not very clear where the invention lies. They say that, okay, there are these 5 different sensors, I would call, that's the one, they're the ones that are giving an output, and there's a model here that sort of receives the input, and there's output that is sort of giving in, the output that is being given out. But is the novelty of your invention in the model? Or are you using a standard off-the-shelf AI model or an off-the-shelf machine learning model and only focusing on what inputs are coming in and what output is going out? This is extremely important, according to a patent drafter, for him to appreciate and understand where the inventive step lies. If you're using an off-the-shelf model, which is what the third point says, if that's the fourth point, if an off-the-shelf model is used, then we have to focus on what and how the input came in, and what was the output and its application at the end of the day. But the third point in turn says that if the inventive step lies in the model, then input and output values don't really have a lot of bearing, because then the focus of the claim should be to describe how the model is being created, the AI model or the ML model that I'm talking about. So it's very important for us to segregate and understand before drafting an application or the claims thereof, is the invention in the input, is it from an industrial application standpoint? Are we more concerned about using an off-the-shelf artificial intelligence model, and are we improving the manner in which the input is being given, the kind of input which is being given, and the output which is going out and the application thereof, which is more functional in nature? Or are we actually focusing on the model per se? But if the scenario is the other one, which is where the model is where the inventive step is, then the input and the output values don't really have a lot of bearing, and ideally should not even come as part of your independent claim and should actually be focused upon. It could be a generic expression which says that you receive a first set of data packets and a second set of data bytes, and then your model, which is how it is constructed, has to be explained in the first claim, and there's an output which is, say, a third set of data packets which is given out. And what those first and second and third set of data packets are could always come down in your subsequent dependent claims as well. So it's very important to segregate the two activities. If you use an off-the-shelf, as I said, then the input and the output are the ones that have to be focused upon. And then the second last point again says that if an off-the-shelf model is used and is configured in a particular industrial use case, so if there are a lot of inventions where input and output are not so much the key inventive step, but the model is, but the model, they're using an off-the-shelf model, but customizing it for a particular industry. It's an off-the-shelf model from a very known industry, but they're customizing it so as to be able to use it in a particular industry, automobile, robotics, whatever that, IoT, whatever that machine would be. But the modification done to that model has to be claimed explicitly in the independent claim for you to be able to substantiate the change, because the examiner is going to use that. In the background section and the detailed description, you will have to explain that this is the model that we are taking, because if you don't really either name the model that you are relating to, the examiner is going to find out a model that has the same characteristics and the manner in which it is learning is exactly the same, and he's going to apply it there. So unless your claim explains the manner in which you've characterized that model or customized that model so as to suit this particular, because the patentability would essentially only lie with that modification. The examiner is going to only look at that modified component of it, and if that modification is big enough to overcome the inventive step objections, then you will get a patent. So it is very important, maybe in the characterized portion of the claim, to indicate that, okay, I'm using these 3 steps. I'm receiving this data, I'm construing or constructing a neural network, and I'm actually running certain regression algorithms, wherein said method is characterized by the step of, and then you say that these 2 steps, I'm doing it because it suits this industry and it makes the model better from an efficiency standpoint. Last point talks about over-reliance on common use. So this is where I started from. That if you use words like neural networks or reasoning engines or support vector machines or anything which is generic in the true sense of it, it would have no bearing. Examiners are very clear and blunt, and they'll very clearly tell you that these are off the book, they're completely standard. Unless you explain what neural network and how you are focusing on it, it's better to stay away from talking about neural networks as the heart of your invention. It's better to focus on what input is coming and how you're going to use the output in a particular application, unless the core heart of the invention is in the model. Next, can I get the next slide? Right. So again, a few set of pointers. These are more generic and not really AI specific. The first one talks about write the technical problem. So like we write the objects of the invention and we write the advantages of the invention in the patent specifications for the Indian applications, which is not really the standard practice in perhaps the US and the European Patent Office. What we've also started doing, even if not as a separate section, we have actually started writing technical problems and technical solutions in the spec itself. Because applications that you file today are eventually going to be prosecuted, say 2 years, 3 years down the line. By that time, the person who drafted may not even remember the context of the invention. And therefore, while drafting, if the inventor can conceive what is the technical problem that I'm solving and what is the solution there to, and if I can document it as part of the spec itself, then when the examiner tomorrow has an issue on section 3K, you can ask him to read para 67 and 73, for example. So you will have a real-time contextual information on what was the mindset with which the application was written. These days, we write objects of the invention and advantages is absolutely a copy-paste of it with just some language here and there. Everybody writes the claims, and then you put the first claim in the abstract, you have the claims that you make the same set of claims almost in a regular English in the summary. These are standard ways that we are drafting. But nobody who's in the software space is actually making specific sections of technical problem and technical solution, because at the time you're drafting an application, that's the best time. And that's the time when you have the peace of mind to write as much as you want to. And therefore, if the technical problem of, for example, a processor time or the standard examples that we have, or even the fact that your machine is the neural network is allowing you to process certain data packets faster or with a better throughput than other packets in the existing systems, it's better to exemplify it in the spec so as to show it to the controllers at the time of the response to the office action that here is what we wrote and here is this section or the paragraph or the cited portion where we tackled this very problem. So if this comes as part of the practice, I'm sure it would help draft applications which will become easier to prosecute or argue upon at a later stage. Write as much as possible at the lower levels of ASI. So the more up we go in the OSI layer, the more functional we are becoming, the more application layer we are becoming. But if we are at the transport level, rather than saying that a user sends a message or he sends a request, it's better that he writes about data packets. It's better that we talk about transmission signals. They sound and appear more technical. So even if your invention perhaps pertains to a clear functional aspect of how a billboard should advertise certain data, you don't have to use those words like advertising. You have to look about, say, a tangible object displaying a set of data packets, set of data packets being received in real time from a server that has certain capabilities. It apparently looks to be technical, at least, even if it is eventually considered or rejected under 3K, but the perception is positive when the examiner reads it. So, I mean, the drafting of an application therefore becomes very critical and therefore should be limited to the extent possible to transport the other layers that are at the lower hierarchy of the OSI structure. Use node-based and the node interactions, packet processing, transmission of bits. These are the right set of words that will help you put a technical character to the invention and help you overcome 3K to the extent it is possible. Avoid writing functional modules. 10 years back, maybe we were writing more about a packet receive module, a packet processing module. But if you look at specifications of companies like Google and others, these days you don't really write words like functional modules. You write words more like units or engines. Like, it's the same subject matter at the end of the day. Invention is not changing, but the way you're expressing it in the patent application gives a more technical character to help you overcome the 101 issues in the US and corresponding 3K issues in India. So avoid usage of functional modules, replace it by actual hardware elements to the extent possible. Couple the method claims. I think it's a standard practice whenever you're writing method claims, try and associate it with the hardware element that is going to execute it, like was seen in the other example. So receiving at a neural network. So maybe a neural network spread across a plurality of computing devices having processing capabilities. So every step ideally should be associated with the element of the hardware constructional element that is going to execute that, which makes the tie-up of the technical character better. It is also important, and I think most of the responses do include as many UK and Indian case laws as possible as while responding back to technical character examples on 3K. So it is also advisable, at least, I mean, as a practice that we guys do, that when we respond back, we look at certain similar granted Indian patents. So case laws are different, which have been adjudicated by a judicial authority. But if there are regular patent applications in a similar domain which have been allowed, nobody stops us from citing it. So as part of the response, there is no harm if you put to the controller that we request you to please have a look at this Dell, so on and so forth, this Mumbai, so on and so forth, which are on the same lines as regards the subject matter is concerned, which have been allowed. So there is some basis on which he will have to go and review the order of that controller of that application, and perhaps would give a bearing on, a positive bearing on the manner in which your application gets adjudicated. The last point is about some simulation results that we should try and substantiate. There was an application from a Gurgaon-based applicant that we had filed a few years back, where as part of the response to the examination report, we had given some simulation results that, okay, this is the prior art system, this is how much time it takes to process, and here is what our system is taking. So if we do a comparative figure on the response time, on the processing time, on the latency, on other parameters which are computational and technical in nature, this is how we are better. So the more you can objectify your results through simulations, the better it is, like we do in the pharma cases through experimental results. The next one. Just 3 examples and I'll conclude. This is an example of the scenario where I've written focus on input and output and not on the ML per se. Now, if you read this, combining the primitive event symbol and the phase symbol for each to form a first vector representation, passing the first vector representation to a machine learning engine configured to identify patterns of behavior for each object classification. This is this granted patent 308-263. This is the title of the invention. So all of these steps are focused on receiving a video frame, identifying images based thereon, identifying all of those images to the objects that form part of that, correlating it to eventually form this first vector representation. And this then says that passing this representation to a machine learning engine configured to identify patterns. So there is no elaboration on what that machine learning engine is. So the core heart of the invention, if it pertains to the machine learning engine per se, then this claim would not survive as an argument. But if you say that I'm using any off-the-shelf machine learning engine, but I'm focusing on the input that is coming to me and how I form this vector, the first vector representation, and how I actually use the output thereof for an industrial application, that is the argument that will survive. But here, there is absolutely no deliberation on which model are you using, and therefore, while responding to 3K, you cannot say that merely because I'm using a machine learning engine here, I'm technical in character. Would not survive as an argument at all. The next one. Here also, the same example, focus on the use of the output value and not on the ML machine learning model per se. It says learning a first pressure point from certain values of the automobile functioning like the engine torque and so on, learning a second pressure point, and then there is the step of determining a probability of adapt values based on at least one extrapolation, interpolation, and adapting so on and so forth. You adapt the pressurized fluid. The point of communication here, the point that I'm trying to make, is that what is being learned is the input that we are getting. And how we are using that input to be processed through any standard ML model, and is that model per se is not my heart here at all. The input is, and how I use that output to adapt the torque converter clutch based on the probability of adapt values gives the technical effect. And all our arguments, all our drafting has to be based around this. If the model is not the key heart, then we have to apply the output to an industrial application and try and focus on the learning being done of technical aspects or technical industrial inputs that would come to you. A method for designing machine and deep learning models, again, this talks. So this is a very good example, and you can take the patent numbers down because I'm running out of time. All granted patents, but the intent here was to show that here the input and the output values were not key. Here, how I've developed the model per se, which is the other part that I was talking about, that this is not an off-the-shelf model. He's trying to make a model per se, and therefore, what input is coming and how the output of that model is going to get used in an industrial application is not key here at all. The key is how to develop this. So at the end of the day, he will essentially try to fine-tune the model and then generate certain subsystems, which is what the model is going to be. So the first two examples that I gave were not oriented towards the inventive step lying in the model. This example is the complete reverse, where the inventive step is the model generation, and hence they've not focused on what that input data is and how the output data is going to get used. And finally, summarization of the whole process. So there are 3 tiers according to how I see it. The first tier is how to generate input variables, parameters for this is the input values basically. These are the output values of how the output is going to get used in an industrial application. And here is the tier 2 of machine learning AI engine of how so this is going to process the input and then give an output. And the intent is if tier 2 is where your inventive step is, then all your claims should talk about in the first independent claim should be the tier 2, which is how that model is being generated. If tier 2 is an off-the-shelf model, then focus on tier 1 and tier 3 as a combination. And that might, and link that tier 3 output, which is the output value, to an industrial application, which might give you an enhanced chance of obtaining a patent. That's about it. Thank you.
Next, we'll have Aditi continuing on the same subject, but focusing on blockchain and IoT.
Morning all, I'm Aditi Subramaniam. I'm an attorney at SNA in Delhi. As most of us are aware, blockchain technologies and artificial intelligence technologies are not the same thing, and so over the next 30 seconds or so, it's going to feel like I'm going off on an unnecessary tangent, but I assure you, if you bear with me, I am approaching something resembling a point. So a blockchain is a decentralized chain of data, an open, distributed public ledger which records transactions in a verifiable and permanent way. The blockchain is not a disruptive technology. It cannot attack traditional business models with a lower cost solution and overtake incumbent firms quickly. Blockchain is a foundational technology. It has the potential to create new foundations for our economic and social systems. Why am I saying this? I say this because blockchain is based on open source client software, as in the source code for blockchain is open source. Anyone is free to copy and improve on it. So the first thing we're worried about here is novelty and inventive step issues that need to be considered. But these could potentially be overcome given the number of ways in which blockchain technology may be customized for very specific purposes. Throw in integration with artificial intelligence and the possibilities increase exponentially. This is the reason blockchain is a relevant subject during a panel discussion on AI. Blockchain and AI technologies may be integrated in a staggering number of ways with obvious legal implications for any resulting IP. Now, just to give us a sense of the types of blockchain-related patent applications that are being filed all over the world, here's a list of some of the areas that they pertain to. Blockchain is most famously being used in modern finance, in cryptocurrency, of course, but also in more traditional areas of finance for making fund exchanges between institutions faster and more secure, speeding up settlement and clearing processes in the stock trading business. Also, since distributed ledger technology, which is blockchain technology, creates a secure, time-stamped, immutable chain of information, it's already finding applications in the brand protection and enforcement, marketing and consumer engagement spaces. It's also being used to track the progress of goods in supply chains, which is of interest to many IP-intensive sectors, including pharmaceuticals, luxury, consumer goods, that sort of thing, where the traceability of goods is important, where counterfeit goods and the gray market are causes for concern. The blockchain is used by Microsoft and Amazon to validate cloud data, by Google to assist self-driving cars, by game developers to validate the authenticity of digital goods. So that's what we're doing with blockchain alone. What does blockchain look like when we integrate it with artificial intelligence technologies? Well, it looks like things like this. Swarm robotics, for instance, the concept of several physical robots working together in a swarm to perform various tasks. It's increasingly being used in areas like medical transport, precision farming, entertainment. Blockchain is a credible solution for increased security of information in this complex maze of information that a swarm of robots represents. Again, something like data sharing. It's often challenging for researchers to access large data sets relevant to their research. There are privacy and security concerns on the part of data owners. Larger companies are unwilling to make their databases public for fear of losing a competitive advantage. So what do we do with blockchain here? We combine it with artificial intelligence. The blockchain functions as the access layer. It controls access to data. And the AI facilitates the running of algorithms on the data without actually revealing any information to the players involved. So the blocks on the chain are essentially secure data silos, permitting researchers to run algorithms in these silos without actually seeing the data. So this minimizes the necessary level of trust between the data owners and the researchers, but also permits data sharing between smaller market players to level the playing field against the giants. Now, why am I talking about all this? I'm talking about all this in order to make my original point that even though blockchain is based on open source client software, and so you would think that novelty and inventive step objections are a hurdle, and they're not as big a hurdle as what comes next because of how specifically you can customize blockchain technology, as I just went over very quickly. The real hurdle is in terms of patent eligibility. Given the way blockchain technology works, getting a patent for it is akin to getting a software patent based on an abstract idea or an algorithm or a computer program, because the functioning of the technology is based on a series of steps performed. Now, what are the specific hurdles we're dealing with in the Indian context? The Indian Patents Act proscribes from patentability a mathematical or business method or a computer program per se, or algorithms, as well as a mere scheme or rule or method of performing a mental act or a method of playing a game. Now, in barring computer programs, mathematical methods, algorithms, and so on, the legislative intent, and this is very much like the US, EU, the UK, the legislative intent was to ensure that abstract ideas, or what the US Supreme Court has referred to as the building blocks of innovation, in order to ensure that the building blocks of innovation remain in the public domain. Now, this was brought to the attention of the Joint Parliamentary Committee in 2002. the then version of Section 3K, which is up on the screen here, it didn't contain the words per se. It barred computer programs generally from patentability. It was brought to the attention of the Joint Parliamentary Committee that that could not have been the legislative intent behind the Patents Act. And so a subsequent amendment of the Act incorporated the words per se into 3K. It's a little bit like the words as such in the corresponding European Patent Convention provision. So this clarifies that while standalone computer programs are patent ineligible, computer-related inventions generally could be patent-eligible subject matter. Now, there is case law that has developed on this theme. So the Delhi High Court in its 2015 Erickson decision said, here we are, that any invention which has a technical contribution or a technical effect and is not merely a computer program per se is patentable. So this is very similar to the current EPO approach, which is to identify the closest prior art, identify the distinguishing features of the claim over the closest prior art, which provide a technical contribution, and then assess whether these features would be obvious to the skilled person in light of the technical problem being solved. Now, in 2017, the Indian Patent Office updated its guidelines for the examination of computer-related inventions. And the updated guidelines tell us that the substance of claims has to be examined, and that the subject matter which is patent ineligible under Section 3 cannot magically pass muster by the use of certain language or by the use of contrived claiming of hardware elements that are not relevant to the invention at hand. Unfortunately, these clarifications, among other things, have led to a slew of rejections of computer-related patent applications. This is particularly true for the Delhi Patent Office, which became very trigger-happy at the sight of any language in patent specifications that even vaguely suggested that the use of computer programs or algorithms was involved. Now, while some patent applications were granted, they remained firmly in the minority, regardless of the drafting techniques that had been employed. Sorry, these are the computer-related invention guidelines that I was referring to a moment ago. In 2019, however, and there's been a brief reference to this already, a judgment of the Delhi High Court, this is Justice Pratibha Singh, she clarified the law to a significant degree. The law hasn't changed, but it has been significantly clarified. After dwelling on the definitions of technical effect and technical advancement, the court said that the bar on patenting is in respect of computer programs per se, and not on all inventions based on computer programs. The decision goes on to say that patent applications in these fields must be examined to see if they result in a technical contribution, noting that across the world, patent offices have tested patent applications in this field on the fulcrum of technical effect and technical contribution. If the invention demonstrates either a technical effect or a technical contribution, it is patentable even though it may be based on a computer program. So, coming back to blockchain technology specifically, what insights do we have in terms of drafting patent applications that dwell on blockchain technologies? Try to maintain a heavy focus on underlying hardware. In other words, it's good to ensure that the patent application describes a physical, technical system component or components. That's one. Now, for blockchains in particular, it may help to focus more on features of the distributed ledger and a little less on the transactional features, because what we're trying to demonstrate here is that the invention is more than just a computer program per se. The next thing to remember is that we've got to highlight technical advantages achieved by the invention. We've got to ensure that the abstract and the background in the patent specification extensively discuss prior art, disparage prior art if you have to, extensively discuss the prior art, the problems and deficiencies presented by the prior art, and the way in which your specification, the specification in question, is solving these problems. This is particularly crucial if there are no hardware elements to discuss. The next thing to remember is that we've got to explain specific steps of data processing and any interaction between components implemented using the conventional hardware and software. Finally, it's important to make sure that we're using comprehensive and relevant technical details and terminology. In the context of blockchains, for instance, that could include say, security aspects like encryption, hashing, digital signatures, networking aspects such as consensus protocols and smart contract protocols. We've got to make sure also to employ technical drawings, flowcharts, system architecture diagrams, data flow diagrams, transaction process flow diagrams, and user interface screenshots or diagrams. That's all I have for today. Hopefully I've stuck to the time limit. Thanks very much.
Thank you very much, Aditi. Now we have John Cabeca from the USPTO. Before he speaks, he has an interesting announcement to make. Will make us all happy. Forward. Bye.
I wonder what it is. Okay, good morning, everyone. So I'm John Cabeca. I'm here today in my current capacity as the Regional Director for the Silicon Valley U.S. Patent and Trademark Office, which is in San Jose, California, and I'm responsible for outreach and education and stakeholder engagement on IP policy matters for the 7 western states of the U.S. It's by far the largest region of the 4 regional offices that we have. In addition to covering 7 states, it also accounts for about 38% of all the U.S. domestically filed patent applications that we see at the USPTO. But in a few weeks, I'll be transitioning to a new role, and I'm very excited about it, and hopefully will happen sooner, as soon as possible. But I'll be transitioning to Delhi as the U.S. government's intellectual property attaché stationed here at the U.S. Embassy in Delhi, working with my counterparts across the South Asia region, the 8 countries in South Asia. And so very much looking forward to joining all of you here in South Asia, for those of you that are here from South Asia. And very much look forward to working together and continuing the great work that the IP Attaché Office has been able to achieve over the past few years. It opened in 2006, and we have a great team there, and just looking forward to joining them and meeting all of you and helping to do what we do best, and that's working together to help make our systems as strong as they possibly can be. And so just very much looking forward to that role. So thank you very much. Now the cat's out of the bag. But turning to the topic today, artificial intelligence, I wanted to share just a little bit about my own perspective. So I've been at the U.S. Patent and Trademark Office now over 30 years. I started as a patent examiner, and in the late 80s, I remember examining patent applications that were reciting neural networks, and I have to say, back then it was challenging. I can only imagine today how challenging it is for our examiners that are examining these very complex technologies as they've evolved. And I think that the previous speakers have done a great job of kind of laying the groundwork of what has happened since the 50s, since the late 80s, and to computer processing today that have really eclipsed the pace of the innovations taking place when it comes to artificial intelligence. And I believe it's caught most IP offices a little bit by surprise. We at the USPTO, and other jurisdictions around the world, including here in India, have taken great strides to figure out, is our current system sufficient enough? I think you heard some great examples today on ways to navigate the current system in order to get patents through a very challenging series of statutes that exist in every IP jurisdiction around the world. And as artificial intelligence becomes more and more ubiquitous to society, it's as I mentioned, the pace of development is raising even more issues. And do we need to look to the future about what systems are going to best protect innovations going forward? And so globally, we're seeing economies working together to advance the shared understanding of how to best seize the opportunities presented by artificial intelligence. And in the US, one of the things we're seeing is a tremendous amount of interest at the highest levels of government. In fact, last year in 2019, the President's budget request included a $2 billion set aside for research and development specifically focused on artificial intelligence technologies. So this is something that, that is critical to many economies around the world. We heard some statistics earlier about the World Intellectual Property Organization and WIPO and some of their estimates. From what I can see, they're estimating that that machine learning accounts for 1/3 of all identified inventions. And in the past 10 years, AI published applications has grown over 400%. We're seeing similar growth at the USPTO. We receive about 670,000 patent applications from around the world every year, and we estimate about 26% of those are employing AI in some manner or another. We've also, as a result of that, have doubled the size of the examining workforce focusing on AI technologies. But within the USPTO, we've been extremely active, both internally and externally. And I thought I would just take a moment to talk about what we've done internally and the things that we have that we're hoping to implement later this year, and also our efforts externally in working with the stakeholder community to advance AI policy. So internally, one of the newest things that we were able to do, we're kind of excited about this, in April of 2019, we released our enhanced citations. This is the first product that the USPTO has been able to develop that employs AI technologies. And what this does is actually looks at the pool of patent applications and office actions, the millions of office actions that have been issued by the USPTO over the years, and the probably tens of millions of references that have been cited in those patent applications and the resulting patents. And it cross-correlates them to provide enhanced data about the citations that the examiners were making, how they used those citations, what claims were rejected by certain pieces of prior art, and what sections within those references the examiner was using. And this is a project that we had expected to spend several years on, and as a result of employing AI technology to mine through the existing sets of data, we were able to leapfrog our legacy systems and create this product that we released in April in just a couple of months. Also internally, we're working with respect to trademarks and patents, so I'll start with trademarks. One of the things that we've seen increasingly at the USPTO is the specimens of use that have been provided for trademarks. We've been seeing an increased number of those that have been falsified or basically created as opposed to actual real specimens of use. So we are actually testing AI technology now to detect when specimens have been doctored to employ proposed uses of a mark, but not actually designating the mark in use in commerce. The other thing we're working with is actually across the TM5, the 5 largest trademark offices, is we are working on a collaboration project to enhance search systems to improve trademark examination by using AI technology to image match the applications that are coming in the door with existing registrations and systems around the world. So those are things we have ongoing. On the patent side, we've been very much focused on improving our tools that we provide for our examiners to help make sure that their searches and their examinations are as enhanced and as efficient as possible. So one of the things we've employed is a pre-search, that when examiners actually bring up their application for the first time, they actually have an AI search that has been done based on the disclosure of the application and existing prior art in the field to give the examiner at least a starting point of where to conduct their search. And then we've also been employing AI technologies in assisting with the classification of our applications. We have a project going on right now that if you've been an examiner for at least 3 years. We can look at the pool of applications that you've examined. We can create an AI database based on those pool of applications that you have expertise in as an examiner, and we can match that to the incoming applications coming in the door so that we're able to make sure that the applications coming in the door are being routed to an examiner that has a direct skill set in working on those technologies. So we're excited about that, and that's been going along very well and hoping to pilot that later this year. I said, and in the interest of time, I just want to talk briefly about what we've been doing externally. So I'll start with a symposium that we held this time last year in January of 2019, and we brought together industry and academic institutions, governments, IP professionals to talk about what are some of the things that the USPTO and and other jurisdictions around the world need to be thinking about when it comes to AI and protecting AI. And so that started a conversation. We had an open comment period. We received some great comments from that. And then in August of this past year, we released a request for comments that had about 17 questions or so around this spectrum of AI as it relates to patents. And we heard yesterday, one of the moderators kept asking the panelists, can AI be an inventor? And that's definitely, one of the questions that we're grappling with at the USPTO. We currently have 2 applications that we're aware of currently that have been filed solely with the inventor is an AI machine. And so we will have to deal with that in due course. They're not published yet, so we can't really talk about them. But other offices are having similar experiences with applications being filed from AI inventors. We've talked about subject matter eligibility. Those issues are as relevant here as they are in the U.S. And in the U.S. practice, we're trying to figure out, does more work need to be done beyond our own subject matter eligibility guidelines, perhaps even congressional? Does Congress need to act to improve our subject matter eligibility standards to account for these inventions coming from AI sources? One of the more complex areas, I think, is the written description and enablement requirements that go into the applications. One of the things that I'm sure you all know is as the data sets evolve, your results may differ. So you might not be, you may have difficulty creating a repeatable disclosure in a subject matter that you're trying to claim as it relates to AI. And then another area we found really interesting is with respect to the level of ordinary skill in the art. And if the inventor is an AI machine, is a level of ordinary skill in the art an examiner or another AI machine? And these are, again, questions that we're asking the community and the experts to figure out where we need to go next with respect to these issues. I believe some of the exhibitors here have systems that employ AI to detect infringement, and those have come a long way in recent years as well. But what if the AI machine is the one that is actually conducting the infringing practices? Like, who's liable? Who do you sue? These are, again, other questions that we're trying to ask and raise. So we received some great comments with respect to the patent-related questions, and then just a couple months ago, we came out with another series of comments, requests for comments focused on trademarks and copyrights, trade secrets, and things like that, and what other steps we might want to take with respect to protecting innovations in other forms of intellectual property, or do we need a completely new form of IP to adequately protect AI inventions, something along the lines of what we see with data protection. So that comment period closes tomorrow, so you still have time to get your comments in. Sorry. But we have a lot going on. What we plan to do once this final comment period closes is all the comments are available on our website, but we will be analyzing the comments and coming up with a summary of what we've seen, and also a series of recommendations, policy recommendations going forward. And we look forward to having those discussions with the other IP offices around the world and trying to come up with a cohesive mechanism going forward. With that, I'll conclude my remarks. Thank you very much, and I look forward to seeing you here in Delhi. Thank you.
Thank you, John. Next, we have Erik van der Vyver. He'll speak about AI applications from the African continent.
So firstly, apologies. My name is Erik van der Vyver. My surname is very Dutch. I inherited a lot from the Dutch except their height. So if you can't see me over my computer screen, I apologize. That being said, I'm 100% African, born and bred, lived there my entire life. So I'm a patent attorney. I practiced largely in South Africa, but throughout the African continent. So if everything goes according to plan, we won't have enough time for difficult questions because it's impossible to answer questions about 55 countries in Africa. But I'll do my best either way. So I thought you've heard all the practical tips and the drafting tips and all the really important stuff to get your AI-based inventions patented in the various jurisdictions. So I thought what I would do is I'll just point out what is happening on the African continent in terms of sort of the application of AI, the opportunities, and then also the protection based on AI. I just want to check if this is... There we go. Starting off with a couple of quotes. I always love those. AI is the new electricity. I can hardly imagine an industry which is not going to be transformed by AI. Andrew Ng. Next one. 100% of jobs will be different. This is a statement by Jenny Rometty, CEO of IBM, predicting the effect of AI on jobs. Global GDP will be 14% higher in 2030 as a result of AI. This means that AI will drive GDP gains of 15.7 trillion with productivity and personalization improvements. This is a prediction made by PwC in 2017. It'll be interesting to see where their predictions are going now. I'm not sure if you're familiar with a author called Kai-Fu Lee, a Chinese gentleman who wrote a book on artificial intelligence. Highly recommend you read it if you're interested in the topic. Basically, his predictions of where AI is going and where we are with AI at the moment. He argues that much of the difficult but abstract work of AI research has now been done, and it's now time for entrepreneurs to turn algorithms into sustainable businesses. And we've now entered the era of real-world application, and that's why AI all of a sudden is gaining so much momentum. Of course, we've known about AI for a very long time. I myself dabbled with AI in the late 1990s, and I was an enthusiastic engineering student and got very frustrated with the big databases of music that were floating around, and I couldn't find the music that I enjoyed. Of course, they were all legitimate copies, and no copyright protection was copyright was infringed. Just to put that out there. But so I started working as an engineering student to develop a machine learning algorithm that I could train on the kind of music that I really enjoy and let it unleash it on this massive database of music so that it can extract the music that sounds similar to the sort of music that I like. It worked a charm. Unfortunately, it was before the days that I knew anything about intellectual property. Otherwise, I would have now probably been singing in a beach bar in the south of France with enough money in the bank. So it was never patented, but now I think every music streaming machine actually employs similar technology. So AI has been around for a very long time. I'm personally very excited to see how it's being implemented now at a massive rate. So Africa, big myth on the left, Africa is not a country. It's strange how many people still think it's a country. On the right, that's the actual size of the continent. So you can see all the countries that fit quite easily into the geographical space of Africa. It is a massive place. It includes 55 states recognized by the African Union or UN or both. It's the second most populous continent after Asia. It's the fastest growing population in the world, growing at a rate of 2.5% per annum. The world average is 1.09. Currently has about 1.3 billion people, and estimated to be about 2.5 billion by 2050. Estimated to have 1/3 of the global population by 2100. It seems a long time away, 80 years, but because of AI, most of us will probably live to see the 2100. 50% of the population is below the age of 25 in a large number of those countries. It's got a very fast-growing middle class of urban consumers and vast natural resources and enormous growth potential. The largest economies on the continent by GDP, South Africa, Nigeria, Egypt, Algeria, and Angola. And some of the fastest growing by projected GDP growth. I'm not going to go through them all. You've got the list there. The slides will be available. The next slide I find even more interesting. 2019 projections of the top 15 fastest growing economies in the world. On the left is 5 of them are in Africa. Ethiopia, Rwanda, Cote d'Ivoire, then there's Senegal and Ghana. And projections for 2023 include 7 African countries amongst the top 15 fastest growing economies in the world. What are the economic drivers on the continent? Communications and IT is a massive driver. Africa is the world leader in mobile take-up growth, and it's expected to be the world leader for international bandwidth demand growth in the next few years. Nigeria, Egypt, and Kenya were the top countries for mobile and internet use in 2018. Mobile money growth, there are 135 live mobile money services, all operated on mobile phones, and 122 million accounts in sub-Saharan Africa. Transactions on Africa's leading mobile money platform, M-Pesa, account for over 50% of the GDP in Kenya and 35% in Tanzania. It's all mobile driven and all very fertile grounds for AI-related inventions. By 2025, it's estimated that 87% of mobile phones on the continent will be internet connected. As of 2080, that was only 38%. So put that together with the population growth, you see there's a massive number of people who will get access to computer-related services and AI-related services. It's the fastest growing region for new mobile users. Active SIM connections are predicted to hit 1 billion in 2025, up from 747 million in 2018. Other economic drivers, of course, minerals and metals, and manufacturing, which is also fast growing. Currently, it makes up 10 to 14% of Africa's GDP in recent years. Just the last point there is noteworthy because of the cheap workforce, abundant raw materials, and low-cost agricultural products means African countries could replace Southeast Asia as the most attractive and cost-effective manufacturing regions. Something to look out for in future. So how does AI apply to all of this? AI applications and opportunities in Africa. Artificial intelligence can help Africa advance more rapidly towards the offering innovative solutions in the fields of education, which is much needed, healthcare, ecology, urbanism, and the creative industries, and by improving standards of living and our daily well-being. It's a statement by Audrey Azula, the Director General of the United Nations Educational, Scientific, and Cultural Organization. Africa is the youngest and fastest growing population on Earth. Financial resources are becoming available, international corporations are showing huge interest in the African continent. In April last year, Google opened an African artificial intelligence research laboratory in Accra, in Ghana, to address the many political, economical, and environmental challenges of the continent. The head of Google's AI office in Accra quoted, "Africa has many challenges where the use of artificial intelligence could be beneficial, sometimes even more than in other places." It's hoped that AI will reduce the current gap between developed and developing countries by exploring the opportunities and challenges presented by AI. Research institutions around the world focus on issues like increasing access to affordable education and healthcare, making financial services more inclusive, strengthening long-term food security, and streamlining government operations. Nowhere else on the planet is this probably more applicable than in Africa and necessary. We have unique African challenges which provides opportunities for coming up with unique solutions, and a lot of that based on artificial intelligence. It's currently, AI is being employed to great effect in a lot of countries based on agriculture for early diagnosis of crop diseases, and that is practically done with a AI-based application loaded onto a device which is, when it's being used, it's completely offline, and the farmers can walk around their orchards and actually just scan images of their crop and identify diseases before they become problematic. It is hugely increased the yield in the agricultural sector in a lot of countries on the continent. The reporting of cancer data to government, believe it or not, but up to this day, that is a process which is done manually in most countries in the world. Forms filled out by medical practitioners in different formats and then processed manually by individuals trained to do so. It used to take 4 years from the identification of a cancer-related incident to the reporting thereof. Currently in the USA, that takes 2 years. By the use of artificial intelligence and developed to specifically take over the manual processing of those reports, the reporting time has also been reduced to 2 years. It is now on par with the USA. It's an AI created to automate classification and reporting process. Google AI in Ghana is working on a natural language understanding to deal with the over 2,000 languages on the continent. Africa is currently the most linguistically diverse place on Earth. I'm just going to take a sip of water if you don't mind. Other areas where it's still being used, in a developed Western country, if the top non-communicable disease is cancer, then researchers would invest in AI that can read scans and diagnose cancer. Here, which is in Africa, your top non-communicable disease or deaths are coming from government's inability to get healthcare to people. So solving the problem of distributing medication in a rural area is something you wouldn't encounter at all in the Western world. But it is something that can save more lives in Africa than cancer scans in a cell can save in the developed world. So figuring out how to get a minibus loaded full of antiretrovirals from the Valley of 1,000 Hills to Mongolia is not something they would ever think of in the Western world. But we can use AI techniques to do that, and we can save lots of lives by doing that. Apologies, it must be the Delhi air getting to me. AI is also used very effectively in the prevention of crime, detecting gunshots. It's one thing that's recently been employed to great success. Facial recognition tools for crime detection, and also in the anti-poaching, AI is being used to great effect, saving our rhino population throughout the continent. The Revamp clinic product set out to answer a question: why are HIV patients not coming back every month for their antiretroviral drugs, which is one of the biggest problems in the treatment of the disease. And the biggest correlation was found by an AI, was the time of the year. The AI figured out that the problem is not the ARV and the T-cell counts, not the clinical staff. The problem was that people couldn't get transport. That's a good example. So instead of putting up more clinics, the solution was to get more minibus taxis, put money in transport. AI was able to figure that out. Intelligent healthcare systems uses predictive analytics, operational intelligence, and remote monitoring to manage 25,000 patients a month, enabling access control and queue management, intelligent appointment scheduling, medication dispensing, and inventory control. Retinal disease detection is also using low-cost data capture devices employing AI. So the opportunities offered in Africa. Why is it such a fertile testing ground for AI? It has unmatched geographical complexity. It's a cultural diversity and tendency to leapfrog stages of development. And no legacy issues as far as tech development is concerned means companies can move with haste and without historical burden to advance lives across various segments from telecoms, healthcare, financial services, retail, and beyond. Just a quick overview. How do I protect AI in related inventions in Africa? Most of the countries in Africa are part of the PCT. There are 9 non-member countries, which you should look up. There are 2 regional systems, which you may be aware of. The EUREPO system, which covers 19 countries, but also covers about $330 billion of the GDP of the continent. It has substantive examination, but it typically follows examination in other countries, most notably the US and Europe. UAPI covers another 17 member countries with a total GDP of 180 billion of the countries of the continent's GDP. And it's a patent registration system, so acceptance typically within 12 months of filing, which means there is no examination, which means you will get your AI-based patent there. Countries not covered by regional filings are important to note: Nigeria, South Africa, Egypt, Algeria, Morocco, even though you can designate Morocco through a European application, Angola, Tunisia, the DRC, Libya, and registering patents in South Africa, Nigeria, EUREPO, and over there. If you're registering patents in South Africa, Nigeria, EUREPO, and UAPI, you cover 77% of Africa's total GDP and 66% of Africa's total population. That's by filing only 4 applications. So the examination of AI-based inventions on the continent, EUREPO does examine, but you can get software and AI inventions through. It's based on the EPO examination, but they don't follow them strictly. Any other grant in an examined jurisdiction will be persuasive. You may file utility models, which is only examined for novelty. In Morocco and Algeria, claim to examine, but they don't. Applications are simply granted. Awapi, Nigeria, do not examine. So you can get your granted AI patents in all of those jurisdictions very quickly. Of course, practically speaking, make sure that it at least complies with the basic patentability requirements as you would draft for any other examining jurisdiction, most notably the EPO. Kenya and Egypt examine, but Kenya is also covered by a repo. And then South Africa does not examine for the time being, but they are busy implementing a true examination system which will be completely independent, although it is going to be very heavily based on the European system. This is a quick cheat sheet. If you or your clients are interested in filing on the African continent, based on the industry sector, this is a quick table which shows you which countries are probably going to be, or which filing systems are probably going to be most relevant for the various technologies. I believe these slides will be made available, so I won't go through all of them in detail. In conclusion, AI is already having a profound impact on the African continent. Due to its unique challenges and makeup, Africa is a fertile testing and developing ground for AI-based inventions. IP protection is available throughout the continent. The general lack of substantive examination leads to a very high grant rate. So even though enforceability can be problematic in some countries, that too is changing at a very rapid pace. And that's it all I have for today. Thank you very much.
Thank you, Erik. Before the workshop, a couple of days back, I had sent a list of questions that I intended to ask the speakers. Interestingly, they've already incorporated those into their discussion, so we haven't lost much. Just one question I'll ask John. 20 years back, when I was actually prosecuting my own AI application, one thing I realized was that in the patent office, either it goes to the computer science AI examiner, or it goes to the domain field examiner. So the domain field examiner, if it goes to him, they used to get wowed by the AI part because they don't understand it. The same way, the AI person, if he gets it, he doesn't understand the domain field. So, how is the patent office addressing that issue today? Or should we go to a panel of examiners to examine such applications?
Thank you. So it is an interesting question because we have explored a variety of different mechanisms, examination mechanisms over the years, where we've tried team examination, we've tried, but with the focus of trying to make the best decisions we can in the most efficient and effective way. And what it boils down to is, we've come a long way in 30 years since I started and 20 years since your application has been prosecuted. And I think our current focus on the classification effort that I mentioned is one of the efforts that we have underway to make sure that the application is getting to an examiner that is skilled in that technology. And we're looking to AI to help solve that problem. But at the same time, technology creep has bled into every technology across the agency. And one of the things we've done in the beginning of this fiscal year was we actually gave certain examiners, particularly in mechanical technologies, more time to do their job because so much computerized technologies have bled into what was once a purely mechanical technology. And so one of the things we tried to do is address that with more time. But there is also an understanding across all of our examiners that they're supposed to work with each other. So when we see, even when I was an examiner, I had a cheat sheet of who else I need to talk to if the invention dealt more with robotics or if it dealt with photocopiers or whatever it might be. And to make sure that we are talking and relying on each other for search advice and assistance along the way. So that mechanism is actually something we've employed much more robustly than even back in my day, I should say.
Just one question I'll ask Partha. Yesterday I had mentioned this in the awards dinner. Interestingly, the patentable subject matter, you had the machine, you had the composition, you had composition of matter. you'll see that all of them derive either from mechanical or chemistry. Because long back you only had devices and oils and soaps. You didn't have electrical technology, you didn't have software. And now even the reform efforts don't seem to be geared towards adding new subjects like software, algorithm, program. I mean, these are words everybody understands. Why not put them in the patentable subject matter list? Why we are still stuck with this obsolete 200-year-old characterization of technologies? Should that be the way we should go?
Thank you, Jit. At least you are talking about the composition of matter, manner of manufacture in the United States. As far as India is concerned, invention means a product or a process. So we are restricted to product or a process and nothing more. So even in computer-related implementations, either you do a process, a method, which is of course one thing. Other is of course the system claims. Yes, definitely I think while digital and artificial intelligence, computer technology is increasing by leaps and bounds, and normally law lags behind, it lags far behind in this particular case. Yes, that is why I am saying, for example, in India, while we are still grappling with what is computer program per se, how to implement it with the technical we have, now the artificial intelligence has gone way above. So definitely there is a need for one, to bring about changes in the law very quickly, but unless the algorithm and others which are very clearly barred under Section 3, unless they are brought into the subject matter, I think we are going to have a problem. So one is you still have to think whether you want to stop just because it is an algorithm or a mental method of doing, but you are implementing it through an artificial intelligence, whether we should give them a patentability is a big policy question. I think all those things are likely to be examined now, just like the question you put to John. Maybe today there is nothing like an individual who will be able to deal. Even if I am a mechanical engineer, I may not be able to even deal with the advancement technology, even in mechanical, leave alone others. So like an interdisciplinary thing may be required. So if you look at that, definitely there is a change required in the law in order to accommodate the new technologies and new developments, and also new methods of examining and coming out with quick, because again, you may talk about 20 years, but hardly any technology remains in focus for more than 3 or 4 years, except maybe in new chemical entities where you get 20 years easily. But in all other fields, 2 years, 3 years, 4 years is the maximum you're able to do. So examination, grant, and using it to the maximum. So speed, therefore, you must have clarity on what subject matters are eligible, and speed in examination. I think both reforms are definitely required in my opinion. Thank you.
Thank you, Partha. Ashwini, do we have time for one question from the... Yeah, it's one.
Good morning to the panelists. My name is Samir, and I represent an organization called InnoKrish. My question is to John. Hi, John. You were talking about, when artificial intelligence-based invention, or for that matter, any invention that comes to the patent office, the first thing probably that is done is broadly under which IPC or CPC classification that the invention would eventually get classified. Now, my question is, for artificial intelligence, I've been doing patent search for close to 15 years now. For artificial intelligence, I have not seen very relevant classification itself. For example, it's not software because it's beyond software, because it says intelligence. It's not hardware, but it is more than, it's a combination of several things. So, is there a need I'm a little dramatic, but is CPC and IPC really helping us? Because these are enumerative classifications, which means basically they're always catching up with the technology, because once the technology comes up, and then we try to build a classification for that. So always we are in catch-up mode. So is it time to revamp CPC to meet new challenges? I hope my question was clear.
Yeah, yes. It's a good question. One of the, I used to many years ago also be on the classification team, and one of the ways that we do classification, now we do it in partnership with the EPO and the other member countries to the cooperative patent classification, is to first wait until a certain number of patents have been perhaps overflowing a certain subclass of in the classification system, and then we figure out, okay, now that we have, say, 2,000 patents in this one subclass, let's go through these 2,000 patents and figure out what are the subset technologies that exist within that subclass that we can break that subclass down further. And I like the idea of being proactive, but it's difficult without seeing where the technology has gone to figure out what are the right correct breakouts that you need to build further to narrow to narrow the classification down into other subsets within that subclass. So it'd be interesting to see what we could do, perhaps in the future using AI might be able to help us and identify these subsets sooner. And again, now that we do this in partnership with the EPO, and know there are some reclassification projects we currently have underway, I'm not sure if AI is related to one of those reclass projects.
Thanks a lot. I think it's time to conclude. Ashwini.
Actually, I have a question. Sorry. Hello.
I think we'll take the questions in the networking break which we'll have. I request Dr. Agarwal to please come and felicitate with mementos to all the speakers. It was definitely a very interesting session, not being from an AI background, yet it was so interesting. Not a minute of this. Thank you so much for such a wonderful session.